Good evening, everyone, and welcome to the webinar hosted by the Company of Master Mariners of Sri Lanka, the professional organization of Master Mariners in Sri Lanka. Let me first give a brief introduction on ground rules of this webinar. Right now, I have everyone on mute and webcam off to avoid background noises that may distract you from listening to the webinar. Throughout the presentation, the chat box will remain disabled and will activate during the Q&A session. You can enter your questions or comments in the chat box, which will be taken up by the moderator. Also, you can use raise your hand function to indicate that you have a question or comment. Then the host will allow you to speak. Your question should be concise. Today, theme of the webinar is the XPress Pearl incident, risks, liabilities, and compensation. I know that most of you are well aware about the circumstances that led to the incident. For the benefit of overseas audience, I will give a very brief introduction. The XPress Pearl container ship arrived at the port of Colombo with 1,486 containers on board for loading discharging operations. There has been a leaky dangerous goods container, which was said to contain class 8 nitric acid. While she was waiting at the anchorage, fire was developed on board the ship, which was later spread throughout. Salvage company has been appointed to salvage the property. Weather condition was very much unfavorable and firefighting was not successful. Eventually, crew had to abandon the vessel. Subsequently, the vessel sank off the port of Colombo. The incident caused severe marine pollution in the coastal belt and the surrounding area. In terms of risks, liabilities, and compensation, this particular incident is very unique, considering the involvement of salvage, marine pollution, loss of cargo, wreck removal, and declaration of total constructive loss. Basically, all private maritime law subjects belong to one or more of the fundamental areas of private law, namely contract, tort, and property. Commercial law as a fourth category is a specialized area and is a combination of contract and property law. So if you take, for instance, pollution can be categorized in tort law. Bill of lading, insurance, and charter party can be categorized in contract law. Salvages and general leverage can be categorized in property law. So therefore, all fundamental areas of private law have been involved in this incident. So moving on with the webinar, in order to discuss these areas, we have invited two eminent professionals in the industry who will be joining from Singapore. So let me introduce our first speaker. We would like to welcome our first speaker, Captain Francis Lansakara, who is the principal consultant and expert witness at the JMC Nautical Private Limited, Singapore. Captain Lansakara commenced his seagoing career in late 1970s upon completion of higher education in Sri Lanka. He obtained his professional maritime qualification from LBS Nautical and Engineering College, India, Singapore Maritime Academy, and later he obtained his Master Maritime Law degree from University of London. In considering his contribution to maritime education, he was awarded a fellowship by the Nautical Institute, UK. His experience includes more than 4 decades of industrial exposure, among which ship's command, flag state inspection, maritime casualty investigation, expert witness in maritime disputes and handling of insurance claims. Currently, Captain Lansakara is responsible for conclusion of all marine cases undertaken by the company JMC Nautical Private Limited. I warmly welcome Captain Lansakara to the floor. The floor is yours, Captain.
Okay. Right. Thank you, Captain Upul Pelis. Let me put on my screen. Okay. Once again, good evening from Singapore. Warm welcome, and thank you very much, Captain Upul Prilis. I consider this an honor to address this very special occasion, and also considering a very unique case. I also like to thank my colleague, Mr. Jagannathan, who accepted my invitation without any hesitation and also with a very, very short notice on behalf of CMM. So thank you so much. So let's begin. XPress Pearl incident. There are, of course, risk, liabilities, compensation issues. Okay, so of course, this case has got so many parties involved and so many legal areas are involved. So it's not just one particular area, as Captain Upul just said. So we have to deal with all that. So we came to some sort of an agreement that we have made this comprehensive plan or some subtopics to cover these areas. So let's go through that. IMO's first, I will consider this IMO's liability and compensation regime, more or less introduction to what are the legal regimes applicable to this case in very brief. Then we go into the owner's aspect, yeah, the safe operation of the ship, duty of the captain, yeah, which he owes a duty to the rest to protect the life and properties and as well as marine environment. Okay, so we'll have a look at that. And then, of course, we also have a look at the port, yeah, the powers of the coastal states, the harbor authorities, and so on. What are their liabilities? What are their duties as well as liabilities? Yeah, that's also important because if you just only look at the owner's aspect, that is not correct. So in order for us to make a professional assessment or professional discussion on an issue, we have to look at all angles. So and then we also would like to talk about this owner's right to limit liabilities because you know the liabilities are always limited. Yeah, it's actually a public policy. Limitation liability is a public policy as well. Yeah, otherwise the cost of goods will go up. So we look at that. And then last not the least, of course, the important part, the insurance companies are playing. Yeah, that is, of course, in shipping, you know, is P&I clubs. Yeah, and then you got the insurance for the cargo and so on. So we'll go through that. The last two topics went by more or less. My colleague, Mr. Jagannathan, is, of course, expert in this area. He will give more details on that. And the first three topics, more or less, I will consider during the time available to me. So, okay, so let's look at this. First of all, we have to understand this. There are pending investigations and legal issues. Yeah, so we must be very careful. Due respect must be given to the authorities, the courts of various jurisdictions in Sri Lanka, in Singapore, and elsewhere as well. So we should limit our discussion to the professional side of it. Okay, so I know there's Captain Upul Prilis did give you a brief outline, but in order for me to go through my slides later on, I also have to sort out the kind of timeline of events. So I made this index-like, yeah. So these are some of the basic description of the vessel. And then we got the cargo, which I did highlight. This cargo of nitric acid. Port of origin was Jebel Ali, and the final port of destination was Jakarta. In between, probably has to do a transshipment in Singapore or Port Klang. The ship crew identified the leak. Yeah, I did highlight that. Ship crew first identification, there, of course, that's an important event because that's the first notification the ship crew had. Yeah. And the one before that also important because the cargo originated from there in Jebel Ali. So there is some responsibilities there as well. Then request by the crew also important. They make one request on the 11th May. The dates are of course approximate, whichever I could gather, because in order for us to understand the case, we must also have to set up, put up some timelines to those facts. Otherwise, it will be quite difficult to make an analysis. On the 11th May is the first request. On around 10th May was the first identification of the risk. Yeah, the leaks were identified by the crew. And then on the day after, it was a request for the request for the removal of that container from the vessel. But of course, it was turned down. And then again, on the 15th May, another request from India. When the ship was in India, they made a request. Then finally, the ship arrived on the 19th May. Yeah, it's on a scheduled visit to Colombo. Yeah, so of course in Colombo they made a request. Of course, this container is not to be discharged in Colombo, so it has to be on board. But then it's leaking, so they made a request whether this container be discharged or reworked. Okay, so unfortunately, the same day, on the 20th May, this is of course an estimated day, 20th May, reported the fire on board, possibly the leak container from number 2 cargo hold. Yeah. So the identification of the fire was on the 20th. So if you look at the timeline, first loaded on 10th May, and the day after 11, so now 9 days already passed. The ship sailed across 9 days and the container is still on board. Now there is fire. Okay, continuing with the same information, the salvage call on the 24th May. So it's 4 days after only the salvage. Yeah. And then the day after there was an explosion, a reported explosion, followed by abandoned ship. So these are the important things I did highlight, but that is not the end of it because you still have to live with it. Then on the 3rd June, sinking of the vessel, then followed by environmental cleanup measures commenced, and wreck removal yet to happen. So still it's not completed. There's still work to be done. Cleaning, and then of course damages. Yeah, who's going to pay for all these cleanups? And then finally, if they can remove the wreck. Yeah. So there's still work to be done. So this is how I set up this table, because in order for us to understand when we are going through the case to identify certain issues. Okay, so I'll go with the first topic or the subtopic, the IMO liability compensation regimes. And I will go through one by one. So there are quite a number of regimes I know for this case. I did not write all the IMO regimes here. I only selected the very important ones, which I think is important for a case like this. So simply, IMO conventions are important when we are dealing with international law, because otherwise it's very difficult to solve problems with shipping, because they are from different jurisdictions, different flag states, and then when there's a claim involved, how are we going to sort it out? So that's why IMO conventions are very, very important in dealing with shipping. And the next important thing is international nature of the case, because shipping of international nature, because it involves more than one jurisdiction. Yeah, ship belongs to a flag from another country, cargo belongs to different owners, and then the vessel is in another jurisdiction, in this case, it was in Sri Lanka. So again, so some of the conventions, what are the international conventions? Here, of course, some examples. IMO conventions are SOLAS, yeah, safety of life at sea, which, for example, I can say International Safety Management Code, which is a part of SOLAS, and that basically direct us to the duties of the ship captain, the duties of the ship manager, and so on, which is also very important in this case. And then we have MARPOL, marine pollution, and very important also limitations of liability, because ship owners always carry some insurance, because they cannot carry unlimited liability insurance. So the insurance always have a cover, and there is a limitation of liability. So they are covered under also different conventions, and the ship's P&I Club insurance will have cover for that. Then we have salvage and so on. Okay, so how these conventions come into play when there is something happen? The most important factor is that convention has to be implemented in that country. International conventions, just because they exist, does not mean that we can rely on it. It has to be implemented into the legal system of that country. So it's a very important factor we should remember. Okay, so this area is a legal area, which has to be carefully considered when you are filing a case. Again, question as to whether Sri Lanka is a party or not a party to relevant IMO convention. So this is an important question. As we go along, we will see what are the areas that Sri Lanka is a party and what are the areas Sri Lanka is not a party. And then, of course, now it's time to find out what are the ways or the best ways we can proceed. Okay, still within the same. So I have selected, of course, not the whole ISM code, but only few items, few sections of that code. Section 1.2, I believe is important, is because that gives the basic concept, objective of the code to ensure safety at sea. Yes, prevention of human injury, loss of life, avoidance of damage to environment, in particular marine environment and property. So in this case, there is marine environment and properties involved. So duty of care from the ship to be considered on this aspect. And then the section 5.2 is the master has the overriding authority. Also important because the ship was coming from several places, requesting for discharge of this leaky container. If the master has the overriding authority, could he override the request by an office and decide himself whether to call for salvage? So that's the overriding authority of the master is all about. And then the section 8.3, also important because in case of hazards, accidents and emergency, how the company organization can respond. Because the code requires you to have an effective system in that case. So these are all the questions that are going to arise in this case. Okay, still moving on the same topic. Then, of course, you have to consider this IMDG code. The carriage is a class 8 corrosive substance. So continue on the same regimes, yeah, introduction to the liability regimes, the compensation. So extract from the limitation liability convention, which is very important in this case because ultimately payment from insurance has to be considered under any one of these conventions. Yeah, so this is a tonnage convention, which every vessel will have coverage, yeah, for damages done by a ship. Okay, simply allow the ship owner to limit his liabilities. Yeah, so here his means company, not a person, because shipping companies are entities. Yeah, so as you are aware, the shipping company, although here its name is, it actually means a company. Damages damages done by a ship, So here damages were done by a ship, yeah, to the environment, to the property, and so on. Okay, the claims, the calculations are based on ship's tonnage. So if the bigger the tonnage, higher the amount, yeah, it can limit. And the payment are of course given in a term which is called SDR, is known as special drawing rights. Yeah, as professionals, I think we should have some knowledge, of course, not to the extent of a lawyer, but to a general guideline of what are these special drawing rights. So I did, of course, pick up some notes from the convention. Yeah, so this is how it is. Article 7 and 8 means the explanation area above, and also it includes how much it will be paid in accordance with the tonnage. I did not put that because it takes too much of space, and at this time I think it is not necessary because the case is not over yet. The amount mentioned, yeah, convert into national currency. For example, if it was decided by a court in Singapore or a court in London, then it should be converted into that particular country's currency. Okay, then the value is of course governed by the International Monetary Fund, yeah, which is also a United Nations organization. And then finally, the current value, I just had a look at the value yesterday from the International Monetary Fund's website. The value is one special drawing right is equal to 1.42 United States dollars. Okay, so this is just a simple guideline to the regime under this limitations of liability convention. Okay, we're still on the same introduction about IMO International Salvage Convention. Of course, this case has a salvage element. Certain clauses or certain terms of salvage is governed by the IMO International Salvage Convention 1989, and some of the terms in this convention has equivalent to the Lloyd Open Form, yeah, LOF. So the difference is LOF is a contract, whereas salvage convention is an international convention, is not a contract. Yeah, it's a law. Okay, then we have this Bunker Oil Pollution Convention 2001, which is also important because if there's a damage done to the environment by bunker oil pollution, this convention will be useful in order to claim, yeah, to the damages. Yeah, again, the vessel carries an insurance issued by the P&I Club based on a limit. Larger the vessel, bigger the limit. Hazardous and noxious substances. Yeah, this is more of MDG cargo. This convention I have written in italic version because this convention is not yet in force, but still up for signatory. But it will be useful because especially ships are going with DG cargo, corrosive cargo, and if this convention come into force one day, it will be useful. And then, of course, we have the Nairobi Wreck Removal Convention, cover the liabilities of the owner. That will come either now or later, whenever we started removing the wreck. Okay, so not all the things we discuss is under IMO. There are, of course, some outside the IMO. Yeah, United Nations Arrest Convention. United Nations is, of course, is a higher body compared to IMO. IMO is a branch of the United Nations. So United Nations is more respectable and more of a higher body. And the ship arrest is under that. And then we have the Law of the Sea Convention. It's also under United Nations that governs a lot of elements, the authority of the port state, in comparison to the territory. And Lloyd Open Forum, this of course a lot of you heard of. Yeah, Lloyd Open Forum, LOF, and then they also have an additional clause that is called the scopic. Yeah, scopic is more or less dealing with the environmental pollution, specific to environmental pollution. That also under a insurance. So if environmental pollution had been occurred and salvage has been considered under that to safeguard the environment, marine environment, then scopic clause can be useful. And then, of course, the other element that we have to consider is a time bar. Okay, so all the claims you cannot claim anytime. There is, of course, a time limit unless they are criminal cases. So, statutory, of course, if this is under a statute, a particular statute by the government, then there is a time bar. For example, 6-year time limit under the UK law, English law, and also 6-year time limit in Singapore. In Sri Lanka, there is no statute governing the time, but it's between 1 to 6 years within my knowledge. Okay, and then of course, if it's a criminal liability, if somebody wants to make a criminal case, not a contractual case, but it's a criminal case such as pollution can be considered as criminal in one aspect. If it's under a criminal law, then there is no time bar. Okay. And the other thing we have to understand is the priority of the claims. Statutory, where claims from the port authority is known as statutory, and they are above the maritime liens. Yeah, so any other claims will be paid after that. Claims by the port authority will be considered first. So this is a brief introduction of all the issues, claims, the conventions, as well as contractual forms and other relevant statutory materials that can be useful for this case. So next important thing I wanted to discuss is the owner's obligation, because every owner has an obligation. As I said before, obligation has to be considered. Yeah. So what is the guide? What is the terms? Terms of reference is the ISM code, which most of you who are masters are very familiar. Some of you probably right now auditors of ISM, so this code is quite useful. So here are some of the facts. Yeah, the ship crew identified there is a leak on 9th May, and I'm trying to sort of gather some of the known facts and then give some comparison to ISM code. So on the 9th, the first identified, and then we have, I call this stage 1 analysis, and then ISM code is 8.3. Yeah. So application for this is the ISM code 8.3. The company organization response at any time to hazard, accidents, and emergencies. Yeah, whether this really happens. And then the second important is code 1.2 objective of the code, which is of general objectives. The duty of the ship to protect the marine environment and property. And then IMDG code, damages. IMDG code also shows damages to human health and environment by their labels, yeah, by extinguishing their labels. Okay, under the same stage 1 analysis, that's how I look at it. Request for removal of the leaky container at the first port, at Port Haman, Qatar, estimated date the day after. So we are, I would say, still in the early stage, so stage 1. Yeah. So code 5.2 and 8.3 is of my concern for this stage, because whether master could have used his overriding authority. Yeah, he has the overriding authority. I am the ISM code. He does not need to wait for the company's instructions, because It's already given under the code. He has the authority. So did he use that? Or if he did not, why? And the next is company's ability to respond into a hazard like this, which is required under the code, whether done proper risk analysis and so on. If it was done, then you should be able to identify the risk and then followed by action. So these are the questions that we can ask at this stage. Okay, so now we go to the next stage. I did categorize this as a stage number 2. There's a request for removal of the leaky container again at the next port. One port they fail and then again make a request. So these are also certain questions which arise. That is 5 days after. Knowing the hazards, the container is leaking and the hazards, it is going to cause to the rest of the containers and the dangers involved. Yeah, that means fire and so on. So here I did make a comparison with code 5.2 and 8.3 as I described before. They have the same, bearing the same meaning. Yeah. So again, the question is whether the master is using his overriding authority, responsibility to make decisions, or he is not. And then the organization responds again, and now 5 days already passed. Is the organization have an effective organization that can respond to hazards, accidents at any time? Because the code require at any time. These are words from the code itself. So whether the real compliance is there or not, these are the questions I could raise. Okay, let's go to the third stage. Actually, there are more stages, but at the moment, I just put it as third analysis, stage 3. And that is, of course, the container arrived in Sri Lanka. And again, request, but nothing happened. And then salvage crew on board is 4 days afterwards. Yeah, that is after a fire. So these are the things that we can consider, though that is likely to be considered in this case. Yeah, again, the ISM code, those I already described earlier, they are the one applicable here. Then again, I got these meanings, which are the ordinary meaning of how to recognize an accident or incident in a particular case. So stage 1, if you can remember, the identification of the leak, I would say it's more of accidental because it did happen unexpectedly. So it's more of an accidental area. But if you look at the stage 2 and 3, where the vessel is sailing with the container which is leaking and knowing the hazards, are you going to still call it an accident or it is something else? So that's the reason why I have put these terms, the definition of these terms, that is for your understanding. How are you going to term this when the vessel arrives after failing 2 attempts? Are we going to consider this as an accident or negligence? Okay. The third one, gross negligence, is a more serious one, mostly associated with loss of life. Okay. And the interpretation is done by the courts, and different courts have different interpretation for that. So I didn't want to describe that. I leave it blank. Okay, so let's proceed. So my third topic here is the powers of the coastal state. As you are aware nowadays, we are talking about coastal state. And then we have the harbor authorities under the coastal state. Coastal state simply means it's the government of that country. And they can, of course, appoint a body to represent the interests of that country. So Director General of Shipping in Sri Lanka, in Singapore, we call it Maritime Port Authority of Singapore. And some countries, they call it Coast Guard Authority and so on. And this is the maritime zone of Sri Lanka. This is, of course, probably not up to the scale. I have I put it as to give you a basic idea of what are the zones belong to Sri Lanka under the international law, that is the law of the sea. The outer limits are called the exclusive economic zones, and the inner limits, the territorial boundary within the 12 nautical miles, which has better higher authority. Whereas go further, you still have authority with respect to resources and control of marine pollution as in that regard, and as well as the removal of wrecks. So that's the reason why I have shown this map, okay, which give a rough idea whether we are within that zone or not. So of course, this case is within the maritime zone of Sri Lanka. And here is some of the definitions which we have to understand. Powers of the coastal state, definitions under UNCLOS Law of the Sea Convention for this case. Sri Lanka is a party to Law of the Sea Convention. And of course, Law of the Sea Convention is a United Nations convention. It is for the harmonization of laws in maritime industry, including the IMO conventions. So it encourages all states to come into some sort of agreement. So when there is a dispute, there is a system. That's the reason why United Nations Law of the Sea Convention is important. So not only signing up to the United Nations Law of the Sea Convention, but it also must adhere to its other recommendations. So other recommendations such as limitations of liability, wreck removal, Nairobi Conventions are all under this. Territorial sea is known as 12 nautical miles zone. Baseline is from the lowest low water line from the beach or from the land. And then we have the exclusive economic zone, 200 nautical miles. It's quite a large area. And then we have the coastal state. State parties, of course, the Sri Lankan government. And the enforcement carried out, to my knowledge, is the naval forces. And in other countries, the enforcements are carried out by Coast Guard, police, Coast Guard authorities, and so on. And then we have the Sri Lankan Port Authority Act, which covers the ports within the port limits. This vessel sinking XPress Pearl sank within the 12 nautical miles zone, so it's within the territorial sea of Sri Lanka. So of course, the Sri Lankan authorities have the power to remove that wreck and also to charge parties for the liabilities. And then we talk briefly about the liabilities of the authorities, Sri Lankan Port Authority and the Director General of Merchant Shipping, also known as the DGMS. Not only the ships are liable, the port authorities also have a duty. So if those duties are not being carried out, they can also be liable. So that's the reason I have shown different aspects of the case. To provide such fire services, especially when the ship caught fire, there is a duty to extinguish the fire. And of course, wreck removal. To my understanding, wreck removal within the port limits is under the purview of Sri Lanka Port Authority, and in all other areas, wreck removal lies within the Director General of Merchant Shipping, DGMS. In this case, the XPress Pearl is outside the port limit, therefore is under DGMS. Okay, and the port authorities, although they are authorities, they also have liabilities. Yeah, so they can't say just because we are authorities, we are not liable for anything. We can do what we like. Under the common law system, they also bear liabilities. So here is the liability of the port authorities, which is stated under the Port Authorities Act of Sri Lanka. So this is an extract from that. Okay, so if they have done anything wrong, a wrongful action that causes negligence and damages to others, they can be liable as well. So here are some of the examples. Of course, they are not Sri Lankan cases, but common law cases. I'm sure they have a weight on Sri Lankan cases as well, or Sri Lankan issues as well. Here is a CMMSL case, millions of dollars. Yeah, Port Authority became liable because the excessive pollution was caused by an inexperienced pilot, his negligence, and Port Authority wrongfully put that person on that vessel. So that's how the liability arises. Yeah. And here is another one, which is also from a common law country, that is from Australia. That's from Australia. It's a Darwin port. Yeah, this is also another pollution case. So I selected these two cases because it's all about pollution. Yeah, and to find out what are the terms of reference, what are the principles behind these liabilities. And then again, how are we going to decide whether a port authority is guilty? So not just because a ship came and the port authority did not have sufficient time or materials to extinguish the fire and so on. That I doubt very much, unless there is a direct cause. Yeah. From these two cases, what we can learn, unless there is a direct cause, there could not be any liabilities on the port authorities. Okay, the first case is actually the Darwin port case, which is about pollution caused due to direct act of port authority. Of course, they became liable. And the one I have spoken before, CMMSL case, it was a negligence of the pilot which causes additional damages. Which in fact it was a novel act. Yeah, the existing problem became worse because of the inexperienced pilot. So because of that only, the port authority became liable. So these are the principles behind when deciding liability of port authorities. Okay, this is a very recent case. This happened last year. This is also about loss of containers. Yeah, has relevant to this case. That's the reason why I have selected this. Pollution damage caused by containers going over the side. And then this happened in Australia, but they were unable to get the vessel. The ship, they could not arrest the vessel. So what they did was they arrest the sister ship. So in other words, what I'm trying to say, if the particular ship is not around, port authorities still have a chance of getting the sister ship. One of the companies, another ship of the same owner can be arrested. It is happening. It's done. This is only one of the cases, and it's happening everywhere in the world. So this is a recent one, just last year. Still very fresh in my memory, and the facts are already here for your information. So sister ship arrest is possible when they cannot find the existing vessel or it does not exist anymore. It is a clear possibility. And here is another risk factor for the port authority. This happens when a wreck has been abandoned by the owners. When the owner abandoned the ship, he is no longer the owner, right? Somebody else is taking over. Sometimes port authority, they will be in charge of the vessel. So I have given an example. The owner abandoned the ship at the point B in 2021, and then he's no longer the owner from that time onwards. And what happened if the expenses incur in 2023, 2 years later? Who's going to pay for it? There were 2 or 3 cases which happened in UK. They were rejected by the courts when the port authority claimed the expenses from the owner. The court said there is no owner. You are in charge of the wreck. So these expenses cannot be borne by the owner because he has abandoned the ship in 2021, whereas the expenses incurred in 2023. Yeah, so similar issues happen in UK, and the expenses incurred to the port authorities were rejected. So this is just a risk issue which I highlighted here. Okay, then here are the conventions that had been ratified by Sri Lanka, and the convention that had been ratified by other countries, yeah, which has some relationship to Sri Lanka or to this case. Next door is India and Singapore and UK. So these were drawn from the IMO website just a few days ago. So this is the update of our status, ratification of status of various conventions that is quite close to this case. So as you can see, there are a lot of red nose. It's not very good news. And you can see India has got almost all the conventions in line as Singapore and UK. And this is not the end of it. There's the two tables for these conventions. There are a lot of no's in red. And as you can see, India, Singapore, UK, more or less in line. And then again, we can take a look. There's still more to come. Some of the relevant one, of course, I did not take on all. Nairobi wreck removal, which is going to be very important in this case. Sri Lanka, a lot of no's here. Almost everything is no. Whereas India, Singapore, and UK, in comparison, quite okay. Yeah. So this is where we stand. So, okay, now just some background of how the disputes and the jurisdictions will be considered. The best is, of course, the local courts, but you may have problems with the local courts because of certain conventions, international conventions are not being ratified. So there can be problems with the local courts. So in that case, what are we going to do? Convenient forum outside can be considered, and it is quite normal in shipping. So it is nothing new or nothing abnormal. It is possible. So what are the conditions? Can you go and file a case anywhere you like? Yeah, but what's the point? Because you are talking about an owner who is a business entity. He's not a person. Whether he has any wealth in that country, we are going to file the case. So important is his place of business. So this is a registered ship owner. We're considering for ship owner, registered ship owner in Singapore. Yes, maybe he has some business in London or New York, possible. Yes. So they can be convenient forums. And other considerations we must give is to the dispute resolution clause, or sometimes it's called the arbitration clause. If you take LOF, Lloyd Open Forum, scopic environmental protection clause, they are under UK arbitration. English law applied. It cannot be arbitrated or dispute resolved in any other jurisdiction. So these are some of the considerations we have to take into account. And then the other possibility is mediation, international mediation. There are a lot of good mediators around. So where there is a dispute, where the two parties agreed, international mediation is highly recommended, because you know litigation is not cheap, and especially if you go to a country outside the local courts, the legal cost can be quite a lot, and we do not know how long it's going to go on. So that's why mediation can help both parties to come together on some kind of terms to mediate, and that will be useful. So my recommendation is that what measures can we take? What measures can we take in order to be in par with other maritime nations? Of course, ratification of international conventions, in par with other nations, which I have given in the table, will be very, very useful. That should help us to identify and to deal with any issues similar to this. And the other measures I would recommend in this case is, of course, statutes on the local base need a review. And sometimes you can also refer to certain cases, certain legal areas which are not covered under the local laws, which is quite common in a lot of Commonwealth countries, including Singapore. Some areas we do refer to English law. Okay, so it's nothing abnormal. We do that and it's possible. So certain areas which are not covered under local maritime laws, they can be referred to English law. So there won't be legal gaps. That's what I mean. And until we ratify all these international conventions, my view is that we must also have interim measures such as additional security, additional funds, additional precautionary measures such as backup, salvage, backups, salvage materials, and so on, until we have the full force of the law. So that's my presentation. I think I'm more or less closer to the time. So thank you very much. My appreciation to the President and the Secretary for organizing this seminar. And of course, I will wait for the Q&A. So thank you, Captain Nupul, over to you.
Thank you very much, Captain Lansakara. It was an interesting presentation covering many aspects of maritime liabilities. So without wasting much time, I will move to introduce the next presenter of this webinar. Next presenter is Mr. Jagannath Muthu. He's an expert in shipping and chartering practice, NVOCC, freight forwarding, and consolidation, shipping agency, line activities, hull and machinery adjustment, including collision, P&I claims control, defense and adjustment. Also, it includes freight demurrage and disputes, port and terminal claims, cargo damage, and intermodal claims defense. He is also a lecturer and a seminar presenter on shipping practice. He obtained his Bachelor of Science degree from Jawaharlal Nehru University, India, and Bachelor of Laws and Master of Laws from University of London. Mr. Jagannath is a Senior Associate of Association of Average Adjusters UK, Fellow of the Institute of Chartered Shipbrokers, Chartered Institute of Arbitrators, and Singapore Institute of Arbitrators, Indian Council of Arbitration, and Asian Institute of Alternate Dispute Resolution. He is an associate of the Chartered Insurance Institute and Singapore Insurance Institute, and associate mediator of the Singapore Mediation Center. He is also a member of the Singapore Chamber of Maritime Arbitration, Maritime Law Association of Singapore, and International Malaysian Society of Maritime Law. Mr. Jagannath is currently serving as the Director of Now Pte Limited, Singapore. I warmly welcome Mr. Jagannath to the floor. Mr. Jagannath, the floor is yours.
Thank you very much. I hope you all can hear me. Let me just share my screen. I think, Captain Francis, you have to unshare from your side so that I can put my presentation. So if you would be able to share it for me.
I already stopped sharing screen.
Okay, thank you.
Okay, Mr. Jagan, I will share for you.
Okay, perfect. Okay, thank you. Sorry for the snafu, but it generally happens when we do something, you might have some last minute issues. I hope you all can hear me loud and clear. Good evening, everybody. I must first thank the company of Master Mariners of Sri Lanka for inviting me to speak on this burning topic, along with Captain Francis Lansakara. Before I start, my sympathies lie with both the owners of XPress Pearl, who have suffered a major loss, and the people and government of Sri Lanka, who are actually have to deal with this situation. Hopefully, after this casualty is over, when everything is over, we all will go on to learn to try and avoid these things. So, a lot of things are developing, but I thought I share my thoughts. So this is my intention to just share my thoughts, and I'm happy to take in comments, observations from participants. So that way is there. The views given are of mine. This is not a legal advice. So in case someone is involved in this casualty, I would like to have a proper legal advice. I would recommend to take a proper legal advice because the facts are developing. There is no one way or no one right way. There are many right ways to reach to the destination. Can I have the next slide, please? I'm actually going to take this presentation into 6 parts. I will touch on the background. I am aware that Captain Francis has spoken on the background, but I will touch on those parts which are related to the liability aspects. Then I'll touch on the cargo liabilities. I will talk both on the Hague and Hague-Visby rule defenses, the fire defenses under Merchant Shipping Act, the ship owner's limitation of liability, which Captain Francis has touched upon, the 76 Convention and the 1996 Protocol. I will touch on both the bunker and the wreck removal. Then I will touch on salvage, both the Lloyd's open form and contractual salvage. And then finally, I will, give my thoughts. So that is over. I think then we are all ready for question and answers. I'm aware that after the end of our presentation is the cocktail time for people in Sri Lanka. So I will not overextend my welcome. So I'll try to keep it as crisp as possible. Next slide, please. Next, please. Yeah, can you go to the next slide?
Give me some time.
Yep.
I can't share it. Yes.
Okay, the XPress Pearl is with a gross tonnage of 36,150. This gross tonnage is important because it will depend on the value as far as the limitation of liability is concerned. The limitation of liability is pegged to the gross tonnage of a vessel, which I will touch in a later slide. It is registered at Singapore, is a single ton, which simply means it is registered to a company which only owns one ship. The possibility of sister ship arrest, which Captain Francis did touch on his presentation, is remote because there are no other vessels owned by this registered owner. At the time of the incident, this vessel was bareboat chartered by another company. I am not aware whether they are, bareboat charters of other vessels, but my web search that did not reveal that they are owners of any other vessel. So even if you want to go after a vessel which is owned by the bareboat charterer, it appears to be remote. The value of the hull, again, according to newspaper reports, is about 44 million. This, as you are probably aware, was a very young ship. It was barely 3 months old when this unfortunate incident happened. There were 1,486 containers on board. The actual figure of cargo values on board, I am not aware. I would assume that the average register would have some figures when parties had submitted. But I have taken a rough indica, so to say, about 30,000 per container, USD 30,000 per container average cargo value. And I also factored in containers because container values have indeed gone up in the recent past because of container shortages. I've taken that about $2,000 per container. And when I do up these sums, it comes to about USD 48 million. So if you look at it, property at risk or property which has got lost by this is 44 plus 48, somewhere about 92 million. So that is what is lost. The vessel is insured by London P&I, is one of 13 IG P&I clubs. I will touch on what is IG P&I mutual later in one of my slides. And its hull is insured by various insurers, the lead being Swedish club. I'm not aware of the terms of the hull coverage, but I would assume it should be one of the common forms, either the English form ITCH 11083 or the Norwegian form. But that doesn't make so much of an impact on this because those is the cover which is given is more on property cover. Captain Francis already touched on the sequence of events leading to this incident. So, I'll just say, okay, there was a fire on vessel on 25th May. The cargo on board this vessel was loaded in Jebel Ali. In fact, the container which caused this incident, or the container which is supposed to have caused this incident, in addition to other factors, which is still, being investigated, was actually loaded in Jebel Ali. What would happen is, whenever cargo is loaded, there would be a contract of carriage, and which would be evidenced by a bill of lading. The bill of lading would invariably provide for application of a clause paramount, which will provide for the Hague or Hague-Visby rules. Additionally, countries have made the Hague or Hague-Visby rules compulsory applicable by law if shipment is loaded in their shores, so to say. The Hague or Hague-Visby rules application is on the basis of where the cargo has been loaded. It's an outward bound convention, so to say. All the three countries, Jebel Ali, Qatar, and India, although all of them might not have signed the convention, they have implemented the Hague-Visby rules with modification such that the impact is the same. I'm also touching on Hague rules because the Hague rules were the earlier version, because the difference is not much. Perhaps if you have another incident and when someone talks about the Hague rules, then you can see that, I thought I'd give you the difference on this. So I will touch on that specifically. Insofar as Sri Lanka is concerned, Sri Lanka has implemented the Hague-Visby rules. Again, it has got not so much importance insofar as this incident is concerned, because we are looking at the Hague or Hague-Visby rules as at the port of loading, not at the port of discharge, or the cargo which was meant for Sri Lanka. You have to also look at one of the articles in the Hague and the Hague-Visby rules, Article 8, which entitle a carrier to also have limitation of liability, which may be available under other conventions. So, whereas, invariably carriers would be looking at the exclusions and limitations of liabilities, which is available under the Hague or Hague-Visby rules, it does not disentitle them to look at other conventions if that is more favorable. And in a casualty like what we are seeing in the XPress Pearl, I would believe this is what they would be doing if they would need to do. Both these conventions also have a defense known as a fire defense, which is provided in Article 4.2b. Unless the fire has been caused by the actual fault or privity of the owners. In order for an owner to exclude liability using this defense, there are two requirements. They would need to prove that they had exercised due diligence at the beginning of the voyage, which is provided in Article 3.1 of the Hague-Visby rules, and that they have taken continuous care of cargo whilst under their responsibility, which is provided in Article 3.2. So if they have done this, then they are entitled to exclude liability. If they are unable to exclude liability, then a carrier or owner would be entitled to limit liability. The difference in limitation figures, insofar as the Hague rules is concerned, it is on the basis of 100 pounds sterling. I did check when I was making this presentation that the value of GBP, Great British Pounds, is about USD 1.73 as of today. So if you look at 100 pounds, it should come to about 173 United States dollars, which is not a very big amount for a package. Having said that, Article 9 of the Hague rules does provide that it should be for gold value. And fortunately, there are earlier cases which have decided it should be basis the value of 100 British pounds as per gold value. And my recollection is that on today's date, it should be somewhere about USD $7,000 to $8,000 per package. So in some instances, the Hague rules may actually be more beneficial than looking at the Hague-Visby rules. The Hague-Visby rules has moved on. It has increased the amount, so to say, to SDR, special drawing rights, 666.67 per package, or SDR2 per kg, whichever is higher. Captain Francis already spoke about SDI is basically a basket of currencies because there's inflation can lessen the value. So basically you have a basket of currencies so that the effects of inflation is not made. Some countries like Singapore have given a fixed equivalent in their own currency. So you need to see which convention applies, which country's convention applies, and then look at that application. Finally, one of the other provisions which we need to be aware as far as cargo claims is concerned is the time bar provision. It provides for 1 year from the date the cargo has been delivered or should have been delivered. In the case of XPress Pearl, the cargo was meant to go not only to Colombo, it was meant to go to Port Kelang, and it was transshipped to other places. So it is not the date when the vessel has sunk, it is the date when, if the voyage had continued, when the cargo would have been delivered. It's after the discharge, there would similarly be some more number of days for delivery. And then you will have a 1 year within which you could actually pursue your claim. And the strategic or tactical thing which every carrier would do is to see if parties are serious in pursuing, because if they are not and the time bar is engaged, then they would probably deny the claim on the basis of time bar. If a party is serious that, listen, I have a valid claim, they would then pursue in a jurisdiction, in a competent jurisdiction, to ensure that the time bar is not invoked or it is not lost, so to say. So yes, you would have to look at 2022 somewhere in June or July, depending on what's the time bar, and then that's where you will probably put look at an exposure as far as cargo is concerned. So that is related to the Hague and Hague-Bisbee rules. In addition, some merchant shipping acts do entitle owners to have something known as a fire defense. I have checked the Sri Lankan Merchant Shipping Act. It does not have any provisions insofar as the fire defense is concerned. However, both the Singapore Merchant Shipping Act and the UK Merchant Shipping Act have a provision for fire, which entitles an owner to exclude liability for fire unless from personal act of omission of owners committed with intent. The same wordings you will find as a barrier for limitation of liability on the LLMC 76 convention. I believe it would be very difficult for owners, to be excluded from this act. So it's a very strong defense, so to say. The reason why I'm touching on Singapore is this vessel is registered in Singapore. And obviously, we don't go in a vacuum. If you want to pursue, you probably have to go through assets. So then you'll probably look at Singapore if you want to pursue. And if he has an entitlement to exclude liability, if he has got some defenses, he should be entitled to do it. Also, the Merchant Shipping Act or different countries have signed something known as a limitation of liability conventions. The reason why limitation of liability came is shipping, owners of vessels are carrying cargo, which is much more than the value of cargo. If they are going to be liable for the full value of the cargo, they would not be interested in doing business because it would be, the insurance cost would be very, very significant. It would not be viable for them. Therefore, nations, as a matter of public policy, have allowed some sort of a limitation of liability for the owners so that, if there is an incident, they can limit their exposure. Sri Lanka is not a signatory of any limitation of liability, which means that, they're not bound by it and they can go for owners for the full value. There are two main conventions. One is the 1957 convention, which has lower limits, but could be easily broken. The 1976 convention has higher limits and also has a provision wherein you could increase the limits considering that, prices of things keep on going. So you have the 1996 protocol, which some countries have signed on, but it's very difficult to break. It's like, yes, the consideration is you pay for a higher amount, you have limitation as of right, but very difficult to break. So both Singapore and UK are actually on the 1996 protocol to the 76 convention. So yes, owners, because it's a registered, the vessel is registered in Singapore, I believe they would be entitled to initiate, limit liability as of right. Next slide, please. If the 76 convention is invoked, the limits are based on the gross tonnage, and it would be approximately USD 20 million for property claims. So I did mention the value of the vessel is approximately 44 million, but if you're able to limit liability on the 76 of this only for property, I'm not taking for personal injury, because there is a separate amount which can be invoked for that. I'm only touching on this. The 76 convention also allows owners to limit liability for wreck removal claims and other claims. Having said that, some member nations have actually put a reservation on the convention, saying that they would not allow owners to limit liability for wreck removal or pollution related to the wreck removal. Singapore has actually made these reservations for both wreck removal and pollution, other incidents related to the wreck removal. I think it's Article 2D and 2E of the 76 Convention. So those are not, in those countries which are there, is not, limitation is not allowed for them. Insofar as the pollution claims is concerned, I'm sure all of you would be interested to know what I could see from the newspaper reports, that the pollution is more with the cargo. And I think it's more to the plastic basins, which are creating a lot of pollution due to this incident. It's still being assessed, but I believe Sri Lanka has said that it's about 40 million. I think the owners P&I clubs have made an interim payment of a few million in the single digit, 2 or 3 million. I'm not aware exactly how much, but I think they would, that would come under, again, you could, if the LLMC was there, they could do it. You have another convention known as a bunker pollution. Fortunately, in this, again, there are two schools of thought. The owners say that there is no bunker pollution, but I did see some newspaper reports that there is a sheen of oil some places coming from the bunkers. So yes, if there's bunker convention, it entitles owners to limit liability based on the 76 convention. Sri Lanka is not a signatory. Singapore and UK are both the signatory of these conventions. Yes, can I have the next slide, please? Then you have the wreck removal convention. You have the Nairobi Convention, which basically entitles member states to have a direct action against owners and the insurers. But the maximum limit is as per 76 Convention. Sri Lanka is not a signatory. I've already said that some member states have made a reservation in the 76 Convention, saying that the limits do not apply for wreck removal. So this both Singapore and UK have made this reservation. So they have a direct, entitlement to do it. But what would happen is they would not be, limited as far as the limitation is concerned on that aspect. So if you look at limitation as a concept, what would happen is, it allows everybody to focus. It allows everybody to take insurance at a rate which is workable. And it allows them to draw the claims to one central place where they can deal with it. So owners of XPress Pearl would, as it develops, they would be considering what they need to do with the claims. They would, if they can exclude, obviously they would exclude. I think exclusion is available under some of the convention of the Merchant Shipping Act. And they're not able to do it, then they will look at limitation, because that is allowed to be there. Moving on to salvage. What happened is, when the vessel was on fire, owners called salvers to assist. Invariably, salvers are engaged either on contractual basis or under Lloyd's open form. The advantage of using salvers on the Lloyd's open form is you don't need to discuss on the terms. The industry knows the basis of how salvage is going to be done. And when the property comes to a place of safety, when the salvers tender the property to a place of safety, they would require security to release the salved property from their lien. And then they will arbitrate at Lloyd's of London on the salvage arbitration to work on the reward. The reward is basically of two types. One is the Article 13 award based on this convention, which talks on which basically deals with the value of the property, with the expenses incurred, the difficulty. It is focused on the property. The London Salvage Convention actually did a groundbreaking part by also saying, listen, salvers also have a duty to try and avoid pollution or prevent measures for pollution. The problem in salvage is, you're only entitled to a reward on the basis of property saved, and salvers would obviously not be interested to salve any property or be involved in it when there's no property which is there. But there is an Article 14 award in which, during the arbitration, they will look at what is the expenses which the owners have incurred, and they would give an award so that they would reward him even if there's no property saved, if measures have been taken to try and reduce pollution or environmental aspects which are there. So this is the Article 13 and Article 14. Article 13 award is given by the property interest, which is the cargo, the vessel, and the freight if it is at risk. Invariably, in container vessels, freight is not at risk. Freight gets merged into the value of the cargo. Article 14 is more given by the liability insurers, the P&I insurers. These are calculated separately. If the Article 14 award is much more than the Article 13 award, the difference is paid by the P&I club. If the Article 13 award is more than the Article 14 award, then the property interest pays the Article 13. The industry participants in salvage were not very happy with the Article 14 wordings and this application by the courts. Therefore, they agreed on something known as the scopic clause, special compensation clause, which they may say, if a salver says, listen, I want to have a scopic clause in my Lloyd's open form, and if they feel that the salvage is not reaching a useful purpose, they may invoke the scopic clause. What it does is basically the salver is entitled to a fixed rate for each day when he does his job. So the advantage of having the scopic clause is you have security. I think as soon as scopic is invoked, the P&I insurers have to give security of USD 2 million, and subsequently they ask more for it. And the salvers know that they will be paid. Subsequently, when everything is over, the rewards will be calculated, and the scopic award, scopic calculations is much less than the Article 13 award. Then the difference, there will be a reduction by 25%, some sort of a penalty which will be given to the salvers, but it is much more than they would get the difference from the P&I insurers. In the case of XPress Pearl, there is no property saved, so it will be mainly on the Article 14 of scopic. And I'm not aware whether they had a scopic clause, because in the London's salvage website, it is not mentioned whether scopic is there or not. But I think it will either be Article 14 or it will be a scopic. Sometimes salvers do not want to go on the Lloyd's open form because they think it's not worth it. You're not going to make any money. The vessel is a total loss, or the difficulty is too much. So they prefer that they sign on contractual terms. It can be rec hire or whatever other this thing. So in those circumstances, it is on the basis of contractual terms. And the way it is done is, if there is a useful benefit conducted by contractual salvage, those costs are entered into general average under Rule 6 of the York Antwerp Rules 1994 or any other edition, and then it's adjusted on the basis of property saved. So that is another way to do it. And sometimes port authorities provide assistance to vessels, and they are entitled. You can look at the Ever Given, which was a recent casualty, wherein the Suez Authority asked for 930 million, and they whittled down to figure. I think it should be about 200 or less million. I do not know, because it is still shrouded in secrecy. Because they said that they did common law salvage, they assisted in reducing, and they're entitled for award. So in this case, there is no property, so there's no property to give award. However, if someone has saved any life or assisted from getting the crew out, they are entitled under common law to something known as a life salvage. Generally, it is given by some countries, which is provided in the Merchant Shipping Act, or even the P&I clubs have a provision in their rules to provide for life salvage. Next slide, please. Which leads me to move on to P&I insurance. Over 90% of the ocean-going vessels are covered by the IG group of P&I clubs, which are formerly known as mutuals. They are a club. They are not an insurance company. The way they pay the premium is by calls. I think it is done at the beginning of the policy year, and then subsequently calls are made depending how the policy year proceeds, and later a final call is taken. It is not strictly insurance, because in insurance what happens is you pay a premium and then you have a cover irrespective how the year develops. So because of this unlimited liability, because shipping is dynamic, there are different practices, there are different issues. The mutuals were formed, and that's how they deal with it. They have a specific rule which I would like to emphasize on: a pay to be paid rule. It is if there is a liability for a reimbursement under the P&I club's policy wordings, then what the member has to do, he has to first pay the claim, and only when he has paid the claim can he seek reimbursement. The issue which arises is if the member goes bust or it doesn't have any resources to pay, then obviously the P&I wordings would not trigger. So this is the issue which comes. So, but as far as English law is concerned, this concept has been there. I think it's an anachronism. We can have a separate debate whether it is correct or not. But as I feel, this is something which is there and it is continuing. So if you have the P&I club, this is something which you should be aware. The member has to pay first, they're only entitled for it. For those conventions where the member states have a direct, right of action, there are rights separately. But if there is no direct right of action, you need to go after the tortfeasor or the person who's at fault. You need to go on the contractual route or the person who's at fault, and that's where this issue will come. The balance 10% is on the basis of fixed premium clubs. Basically brown water. You pay a premium at the beginning of the year, and they irrespective of how the policy year develops, the cover is in place for that amount. The advantage of going for a mutual is, mutuals say that they have unlimited liability or they have a very high liability. I think the fixed premium clubs also do have. In fact, the mutuals are reinsured in the fixed premium market or reinsured in this thing. So the difference is not there. But having said that, owners prefer mutuals for their flexibility, which is there. I did touch, irrespective of what it is, you have some direct action available. So that is the reason why some of these conventions are useful. On the fixed premium clubs also, I must say that the wordings of some of the clubs, does provide for a indemnity. So it could be argued the effect should be similar to a pay to be paid rule. I have not seen a specific case for a fixed premium club. I think it would be taking a stretch too far, but we'll see how it develops. This is something which we should be aware. I think insofar as this casualty is concerned, casualty is developing in the sense that investigations are on. The owners would be doing the investigation. The Port State Authority of Sri Lanka would also be doing investigation, what exactly happened. So this is something which we would need to see. And obviously I will not give any thoughts on this because the facts are still not out in the open. Insofar as property is concerned, I have my sympathies, but there are limited chances of recovery. Even if there is any recovery, it would be a reduced recovery because owners would be entitled to limit liability as provided under the LLMC 1996 protocol. So, but like I said, we talked about the Hague rules and Hague-Bisbee rules. We also talked about the Merchant Shipping Act. The chances are the owners would try to use that. Insofar as the other issues are concerned, the pollution and wreck removal, I think the P&I clubs will honor their commitment. They will do what is necessary. They will deal with the pollution. They will make payments, but it is not a blank check. They would look at it if it is necessary, if it is valid in law, and they'll deal with it. It would be more helpful if you have, some sort of a signature, some convention where you can probably then go on a direct action. In this case, you don't have it, so you would have to go. But I think my view again is, my view is there would be commercial considerations when people would be disquieted if it is not dealt. This vessel is a single ton. It'll be difficult to recover for at least property claims more than the value of the hull or hull proceeds. There's nothing wrong to have a singleton. In fact, all the big ship owners actually use corporate structures to limit their exposure. Although when you are a singleton, when you go and take insurance or when you want to do it, people generally use derogatory terms. Oh, you're a singleton. You don't want to do business. If you go to all the big ship owners, I will not be surprised if they have set up separate corporate entities wherein they have tried to limit or cap their exposure. It's perfectly legitimate and which is perfectly okay. Laws cannot be in a vacuum, and I make this point because Sri Lanka is not a signatory. The question is what laws apply. Actually, before speaking on this topic, I did some sort of research, and there are two schools of thought. Sri Lanka was a colony of the UK, and I believe in 1853, or there is an act which says that if there is no specific law or shipping law in Sri Lanka, then they will follow the law of UK. So arguably, you could argue that, listen, since there is no law, English laws which are there should apply insofar as shipping is concerned. I did speak to my friend, Mr. Poo Balasingham, a well-known shipping lawyer in Sri Lanka, and would said that, listen, there is a Supreme Court judgment which says that there has to be legislation for that to be there. So these are two competing thoughts. I'm not going to make any this thing, but yes, so it would be best if you to have, I think the time has come to look at it from that aspect. If there are no laws, you could still pursue in Sri Lanka. The question is, where is the property? Where is the asset which is there? The earlier speaker has already mentioned that, listen, you need to look at, where the property is, so that perhaps you might have to look at other jurisdictions to pursue or to enforce. And if you have compulsory insurance direct action, well, then, you have a right of going directly against insurance. I think I have done with the presentation. I think I am now into question and answers, and I'm happy for the floor to ask questions to me and my colleague, Captain Francis. Thank you.
Thank you very much, Mr. Jagan, for your very informative presentation, covering mainly cargo liabilities, P&I insurance, as well as the involvement of wreck removal and the pollution liabilities. So, dear participants, we have come to the Q&A session. To begin with, I would like to pose the first question to Mr. Jagan. Since Sri Lanka is not a party to most of these conventions, and since Singapore is a party, can Sri Lanka make owner liable? For instance, Bunk Oil Convention.
The point is, there are two ways of looking at it. Because since Sri Lanka is not a signatory to these conventions, they are not bound by the limits which is there. They can go after the owners for unlimited liability. The issue is, does the owner have the money? Does he have assets? And well, does he have an insurance for that? Now, XPress Pearl as a corporate entity is a singleton vessel. And, the most you could probably look at is the hull proceeds if the hull insurance claim is paid, which is 40 million. If you go after directly the insurer, then you will probably have to look at what is the right insofar it is. They'll say, first go after the insured, so to say, go after the owners. So it's a bit of a round the role. Having said that, I think my feeling is the insurers will deal with it practically, pragmatically, and will deal with the claim as if, Sri Lanka had signed some of these conventions. But there is an argument which will probably say, listen, the vessel is not there. There is nothing there. So there could be an argument made. But that is the extreme this thing. So that is my answer insofar as this question is concerned. Thank you.
There's one question in the chat box. It says, with no self value, will there be no salvage award? How would the salvos and Sri Lankan firefighting be compensated for their efforts?
Okay, insofar as salvage is concerned, I did touch about Article 14 Article 13 award, Article 14 award. I did also talk about the wreck removal and the wreck removal pollution. Insofar as the salvos are concerned, they have actually they did the salvage on the basis of Lloyd's open form. I would assume either they'll get an Article 14 award or the scoping clause, basis the rates based on scoping. So that is, irrespective of being no value. Insofar as the fire saving is concerned, it is to aid with the vessel. I believe you would have a fair claim, and you probably look at the basis of what is looking at, not the salvage, basically what is available under local laws, and you would be able to recover it to some extent from the owners. That is a difficult question, so to say, because you need to look at what is the act as far as Sri Lanka is concerned. But yes, I would assume that the P&I insurers will pay those claims also.
Thank you very much. There is one more question. I will pose this question to Captain Lansakara. As for the environment damage claims, will there be any payment more than the limitation over the strict limited liability figure as per GT? If so, what rules govern that, and from where would the actual compensation be paid from?
Okay, thank you. Very interesting question. You are talking about the damages to environment, and that is unlimited. When there is something unlimited, there are two ways of looking at it. One is the law of tort, and the other is the criminal liabilities. So if you are looking at the legislations in Sri Lanka, pollution laws are under criminal liabilities. So based on the persons who are criminally liable, they can consider criminal liabilities because criminal liabilities do not allow any limitations. So that's my answer in case if you are looking for unlimited liabilities with respect to pollution. Whether the Sri Lankan laws with regard to criminal liabilities are strong enough to deal with a heavy pollution, given this case, is a question difficult for me to answer from this position unless I'm a practicing lawyer in Sri Lanka. So the best answer I can tell you, you have to look at the criminal aspect of it if you are looking at something unlimited, because in all other aspects, there will be limitations. And then also you got to look at whether you are dealing with a person or you are dealing with a company. Most of the shipping cases are companies and not individuals. They are names, they are entities. So you don't see a person there, although they call it owners, they're all entities. So that's the best answer I can give you. Thank you.
Thank you, Captain Lansakara. The next question also to you. Can you explain more about owner and master not complying with their ISM responsibilities? What can happen in this case?
Yes. Owner and master responsibility in the ISM is the duty of care. It's the same thing if you look at collision. Master is not taking action, is disregarding his duty of care. So if you're looking at the legal area, it's of course it's under the law of torts. Torts means wrongdoing. And then your accident causes loss of life or serious damages, depending on how you're going to interpret it. Then you go into gross negligence. Yeah. Then you can also be liable under the criminal laws. So whereas disregarding the ISM, you can look at the same way as disregarding the rules of the road in case of collision. There are captains became liable criminally for collisions. There are also harbor pilots became liable criminally for collision. So the same rule applies when there is a negligence If they find, that's the reason why I have given 3 stages, and also I gave a definition of accident, and also I give the definition of negligence. That is for the person looking at it to have some kind of an idea whether this is accidental or this is negligence or it's more than that. Yeah. So yes, they are liable and they are considered as under the law of tort because it comes under the neglecting your duties. Yeah. And then if your duties exceeds to the extent damage to the extent that loss of life or serious pollution, like this case, it can be a criminal case as well. Thank you.
Thank you, Captain Lansakara, for the nice explanation. And I would like to pose another question to Mr. Jagan. You were talking about direct action against the PNI club. So is the insurers in that case liability also limited to the value of the hull? So that's the question raised.
I think the insurers will be entitled to use the defenses which the owners will be entitled to. If you are going to go for a claim which the owners are entitled to limit liability, then the insurers will take the same defense. There are some claims where you are not entitled to limit liability, like for pollution or wreck removal, which I did say that some countries have put a reservation. So, if you go after them, the insurers would probably have to do unlimited liability of those aspects. But those claims which they can limit, obviously they would limit. I hope that answers the question.
Thank you. So there is another question. Hopefully Captain Lansakara can answer. There were 2 ports who have not taken action, rejected to the request of master. Are they liable too?
Yes, very good question. Also very interesting. First of all, 2 ports, 2 jurisdictions. And who is going to claim? Another third person, probably 3 jurisdictions. And don't forget, you forgot something. This is a leaking container or probably a drum. Where it came from? Another jurisdiction. Right? So everybody will be blaming each other. It's not just the 2 ports. So there are a lot of few jurisdictions are involved. Would you recognize a case? Who is going to claim from you from another state? Are you contractually liable to that person? Definitely not. So you have to apply the law of tort. If both the person are in the same country, yes, it can be done because it is under the law of tort. You can say it's not too remote, it's within the duty of care, yes. But if you are in 2 different jurisdictions, can it be applied? Practically, it's not possible. Okay, but in principle, you can consider. Unless that government think, that state in that government think this is really sympathetic to that person on the other side of it, and they want to take action against their own company or the person liable in that port, there is a possibility. Like Singapore might think there is a criminal issue here and they want to take action against a particular person in Singapore, thinking that Sri Lanka was unfairly treated, and they can take action. So that is up to the government of that country. But if you are going to cross-border jurisdiction, it will be very difficult. I don't say it's impossible, but it's difficult and practically no one can try. Thank you.
Thank you. There's another interesting question. It was having in my mind too. Captain Lansakara, can you answer that? Is the shipper of the nitric acid container is liable? What is his liability?
Oh, shipper, yeah, okay. Okay, the shipper is the same question. It's actually the answer is quite similar to what I just told you. Shipper has certain responsibilities under the Hamburg rules as well as the Hague-Visby rules, because they have certain responsibilities, yeah, and certain liabilities as well. But can you get shipper to be liable to a third person in another country. So more or less, my answer will be the same as I gave you just now, because this is going to be a different issue for different jurisdictions. And you have to see whether this particular person from another country, so that means something unfairly happened to a person in Sri Lanka, and then this person want to now sue the shipper in a country that is WLALI, if I'm not mistaken. So how is he going to do it? There are two different jurisdictions, but if the two persons are in the same country, yes, there is a chance under the law of tort, because they are not contractually binding, because these two persons have no contract. The contract is between the ship and the shipper, whereas the person who became liable is a third person. So once again, two jurisdictions, there is a problem, but if both are in the same jurisdiction, there is a possibility, because this comes under law of tort. That means duty of care. Okay, and it should be considered as not too remote. In that case, yes, it is possible.
Thank you.
Can I add on this thing? I know for a fact that people are actually looking at, can they pursue the shipper? I would probably answer it in a very practical way. The exposure on this vessel is at least 100 million or more. We talk about the cargo is about 40 to 50 million. The vessel value is about 44 million. And your pollution claims, if there is a wreck removal, we don't know whether the Sri Lankan authorities will ask for wreck removal. It can easily go to 100, 150 or 200 million. I'm just banning anything above 100 million. The question is, does the shipper, if he is at fault, does he have the money to pay the claim? If he's a $1 company or a 1 million company or a $10,000 company, that will take the decision. Now, I do not know the exact facts of what exactly happened, whether this cargo only created the fire or was a combination of many other factors, which the investigations will reveal. But if it was due to improper packaging with the cargo which caused the fire, then obviously you can go after the shipper. Generally, you'll find that the shippers who do this are ones who are able to close their tracks or do not have sufficient value. So going after them is only spending good money after bad money. That's my 2 bits on it. Thank you.
Thank you. There's one interesting question here. I will pose to Mr. Jagan as well. As for finding the actual cause or causes of the disaster, finally, whose finding will be upheld as the cause of the accident to punish the culprit or claim the cost of such disaster from?
Okay, I think, I'm speaking to an audience which is in Sri Lanka, and it's very nationalistic in favor. I admit that. I'm speaking as a professional. I think this could have happened anywhere. I think there is a problem in this industry that, people are not taking sufficient, proper management of the cargo. It's just unfortunate that there are some people who get, like the master or the owners, they are there in this. So I have sympathies with them. I don't think they are at fault. The fault is lying somewhere else. We need to find a solution. So as I see it, going after the person at fault, I think I've seen so many of these cases, you would not be able to have any evidence. I think the shipping industry has to learn to find modalities to ensure that we implement things. So let's say if you find a shipper who has done it in Sri Lanka, are the Sri Lankan laws strong enough to prosecute him sufficiently in a quick manner? If, in the other countries, do they have the same way of prosecution? I think there's a lot of lacking which is there, and people who are doing this are able to get away. Unfortunately, people who are nearby are affected, the ship owners and all. I have sympathies with them. I don't think they are at fault. And I think this would be the same in this case. That's a long and short on this answer. Thank you.
Yeah. One question very similar to the previous one. What action is expected from the flag state here? If you consider in the whole scenario, what action can be expected from the flag state? That's the Singapore government.
I think the Singapore government will conduct an investigation on their rules and responsibilities as a flag state, and then they will decide on it. But I believe that flag state investigations are more to find the root cause, and then try to do it on that way. So I think Captain Francis will be more, better on that aspect to answer on this. But this is what my belief is. Anyway, Captain, over to you.
Yeah, thank you, Jagan. Yes, you are right, because flag state, I myself is a flag state inspector. We do not give our reports to the courts. We do our investigation and find the root cause, and also we give recommendation to the owners. The same principle apply to Singapore, because Singapore is under the same IMO convention, under the same IMO code, which gives modalities how to do the flag state casualty inspection. So this is being conducted. At the moment, the report is not out yet, so it will take some time. So if you are looking at flag state inspection is to find causes and to improve the safety standard of the ship, and it will not do things such as liabilities. Yeah, it will not issue liabilities as such. So they will leave that to the industry. Okay, the prosecutor, yes, can take action. Yeah, if they find the criminal element, yes, the prosecutor can investigate and take criminal action against the owners or the company or its individuals. Yes, there is possibility on that. But if you are looking at flag state inspection alone, it's more of a improving standard sort of. Thank you.
Thank you. Shall I pose another question to Mr. Jagan? If the vessel sank in deep water, well away from the land of Sri Lanka, could be a better outcome for the P&I than at present location. In that case, what compensation can be claimed by the state?
Okay, the way I see it is, as of now, I do not know whether the Sri Lankan authorities have decided on a compulsory wreck removal. So it is not a given, and I can be corrected because I'm not deeply involved as far as the wreck removal or the modalities in Sri Lanka is concerned. As of now, I think the weather does not allow you all to decide. So yes, there is a wreck. If it is a danger to ongoing shipping and other aspects, member states or states can pass a compulsory order for a wreck removal, and that is pretty costly. So since it is in a shallow area, the P&I clubs would bear lesser than if it is in a deeper area. So, but if it's in a deeper area, and if there is an order which is made, I think the P&I clubs and the owners could make an appeal in the local courts saying that a wreck removal is not necessary because it is not a danger to shipping. It is not a danger to the environment. So it is just basically doing it. I think there are a lot of wrecks. Let's face it, there are a lot of wrecks which does happen. And deep waters is very difficult to remove if it's fallen down very, very low. I hope that answers your question. Yes, the P&I clubs have a limited or reduced exposure if the sinking is in a shallow area.
There's another question. When the LOF is signed, does the authority of the flag state diminish? And what is the role of the coastal state if the vessel is in their jurisdiction? So this thing came up once. When the LOF is signed, what is the authority of the flag state?
Okay, LOF is the Lloyd Open Form. It's more of a contract or a salvage contract, you can say. So the owner's liability or ownership of the ship still remain. There is no guidelines as such, or there is no clause as such as far as flag states are concerned. Once the LOA is signed, the flag state will diminish. That is untrue. If it is a constructive total loss, it is possible the ship is no longer a ship and it is under somebody else. So therefore, owner does not exist, and of course, the ownership will diminish. In that case, it's true. So LOF signing itself does not mean anything because it's just to say that they require salvage, and it's a salvage contract. So it's in other words, there are a lot of ships. They have signed LOF, they recover. After that, pay according to the salvage rules, and then the ship will be back to normal and the ownership will remain. So of itself will not diminish. And when there is a constructive total loss, the vessel ownership is abandoned, and definitely he is no longer the owner of the ship. In that case, yes, the flag state will consider that person is no longer the owner, and there are guidelines. Of course, if you have abandoned the ship, there are rules from the flag states that how the owner should proceed, the notification process, and so on, and from what time or what date onwards that he will be considered as no longer the owner of the ship. And these rules are depending on from one flag state to another. So there are different rules under different flags, how you should notify, and within what kind of time frames as such. Thank you.
There's another question. What about the obligation of the countries the ship visited prior to perishing in Sri Lankan waters, especially since the ship owner and the master appear to have requested help about the leaky container? So is there any obligations is set out or mentioned in any of international conventions, the obligation of the countries when they ask for help? Captain Lansakar?
Yeah, okay. There is, of course, the Port Authority have general obligations. You don't really need to know the exact what are the obligations that Port Authority should do. Like you can take, for example, Sri Lankan Port Authorities Act. Yeah, they are running a port. There are general obligations in any port that when a vessel comes in, you got to give this sort of services. And also you got to have firefighting services, reworking facilities for the containers, and because you are handling not just one or two containers, you are handling thousands or millions of containers. So there are, of course, obligations in these ports. So who can take action against these ports are the government of that country and not anybody else. It will be, again, going to be a cross-jurisdiction issue. So liabilities, duties, yes. If you look at it in a layman point or an observer from outside, if you look at it, yes, everybody knows that the ports, when a ship requests for assistance and it is necessary, they should provide whatever assistance possible. That is true. But if they did not, on what basis, the only person can investigate, it is their own government. And anybody else, it is kind of interference into their jurisdiction. That's my view.
Thank you. Thank you. That's also a very nice answer. There's another question. What is the difference between contractors, pollution liability, and pollution legal liability? Can Mr. Jagan answer to that question if you understood properly? What is the difference between contractors, pollution liability, and pollution legal liability?
Okay, I think, if you, again, this is my understanding from what I've been, when you talk about contractors, I assume it would be meant for contractors who are doing some job and might be the contract says, listen, you need to take liability for pollution for so-and-so. Contract will be provided. They would go to insurers and take a liability. They'll take a pollution cover for so-and-so, so much pollution. When you talk about legal liability, you would have to see whether you're legally liable. Let's take someone is driving a truck and it has got drums of hazardous chemical, and someone comes and bangs onto the truck. Unless there is strict liability laws, the driver of the truck which was driving could perhaps argue it is not my fault. The fault has been done by someone else. So pollution sometimes has this issue of the strict liability issues there. You don't look at fault, then you look at legal liability. You look at what is a liability as per law. When you look at legal liability, there is a concept of fault or responsibility which is there. So, but insofar as pollution is concerned, or people generally look at strict liability laws are made so that, assets can be paid. So yes, there is a pollution cover which is there, a contractor can take. When you talk about legal liability, you look at from that aspect as what is your fault? Are you liable or not? I hope that answers this question.
Yeah, thank you. Thank you. I think that will conclude our Q&A session. To conclude the webinar, I would like to invite the President of Company of Master Mariners, Captain Mahendra Ranatunga, to extend the vote of thanks. Captain Mahendra, over to you.
Thank you, Captain Upul. Good evening, dear participants. At the very outset, I would like to extend our sincere gratitude to the two panelists today who joined from Singapore, Captain Francis Lansakara, a member of the Company of Master Mariners Sri Lanka, and Mr. Muthu Jagannath. Thank you very much, Captain Lansakara and Mr. Jagannathan, for participating at this seminar. And I must mention that the inspiring knowledge that you shared would be appreciated very much by the audience. I remain grateful to our own Captain Upul Piris, the Secretary of the Company of Master Mariners, and the EXCO of the CMM for organizing the webinar. Finally, I would like to offer our sincere thanks to all the participants from Sri Lanka and overseas for their participation at the webinar. Thank you all and have a great evening and stay safe.
Thank you very much.
Thank you. Thank you, Captain
Thank you very much.
Lansakara, as well as Mr. Jagannath for participating, accepting our invitation to participate this webinar. Hope you will participate many more to come, organized by Company of Master Mariners. We will invite you definitely. And thank you very much for all the participants. Have a great evening. Thank you.
Thank you very much. Have a great.
Thank you. Okay, thank you. Thank you very much, Captain Upul Piris. Thank you very much, Captain Mahendra.
Thank you.
Hope to see
Thank
you all
Thank you
one
once
day.
again. Thank you.
See you once more. Right. Thank you.
Yes,
Bye.
yes, we will organize another one very soon. It was very informative. Yeah.
Yes.